Good afternoon. My name is Andrea Hoover, and today I'll be interviewing Richard Johnson for his thoughts on whether workers may recover for benefits if they contract COVID-19, the novel coronavirus, in the workplace. Now, Mr. Johnson, you're a partner at the Katz Friedman Law Firm, and for several years you have authored the Occupational Disease Act chapter for the Illinois Trial Lawyers Association Handbook. And based on your research and experience, do you agree that COVID-19 illnesses should be covered under the Illinois Occupational Diseases Act?
Well, I think there is no question, Andrea, that workers should be covered if they contract the novel coronavirus, COVID-19, in the workplace. These people work shoulder to shoulder, very close quarters, where they are very likely to be exposed to an increased viral load. It's this increased viral load that presents a greater risk to them than the general public.
So if a worker does contract COVID-19 while working, from a legal perspective, is that considered an illness or an injury?
That's a great question. There has been some confusion, but it's pretty clear that the Workers' Compensation Act does not apply here. The sister act, the Occupational Diseases Act, is what applies. The Occupational Diseases Act covers illnesses and injuries that result from exposures to chemicals, or in this case, a virus.
Okay, so for a workplace exposure, are there any other differences that you noted between pursuing a claim under the Workers' Compensation Act versus the Illinois Occupational Disease Act? I know you just mentioned a few.
Yes, well, there are quite a few differences actually, and they're significant. So when we want to prove an illness is covered under the Occupational Diseases Act, we can use all of the person's average weekly wage. So in the Workers' Comp Act, they take out overtime. In the Occupational Diseases Act, we get to include that. And since all benefits are based on the average weekly wage, this is a critical difference. Another very important difference is that under workers' compensation, you're required to give notice within 45 days of the accident. In an occupational disease, really notice is not an issue. It's whenever it is practical. And in reality, it's only practical whenever you give notice. So it could be years, in fact. And in some cases, that's the case. But for the novel coronavirus, the employer would be on notice almost immediately when you report your illness.
So is an Illinois Occupational Disease Act filed and adjudicated at the Illinois Workers' Compensation Commission?
Yes, it is. The Workers' Compensation Commission is sort of named incorrectly because it does cover the Occupational Diseases Act as well.
Got it. So have you represented workers under the Illinois Occupational Disease Act? I assume you have.
Well, yes, I have. In my career, I've been fortunate, privileged really, to represent many, many people who have been exposed to chemicals in the workplace, radiation, beryllium, all kinds of things that cause injury to people. So I've handled thousands and thousands of cases actually under the Occupational Diseases Act. Most prominently actually noise-induced hearing loss, which is caused by an overexposure of noise over a period of years.
Got it. Okay. So after the COVID-19 pandemic spiked in March of this year, what action did you take on behalf of Illinois workers?
Well, one of the problems with the Occupational Diseases Act is that if you have a common illness, it is difficult to prove that the common illness is related to your work exposure. So we are privileged and to represent many unions, and one of these unions is the Illinois Nurses Association. And we worked with the Illinois Nurses Association to promote to our state legislature that an amendment to the Occupational Diseases Act be created for essential workers. These were workers identified by the governor's order in March of 2020. This presumption was used to create a little bit of a lower hurdle for the worker to jump over so that it didn't automatically exclude contracting the virus as a work-related injury.
So I see that Governor Pritzker has signed into law Public Act 101-0633 for the benefit of frontline workers who've contracted COVID-19 in the course of their employment. Could you explain this provision a little bit?
This provision is what we were working on with the unions, and it is a privilege that creates a rebuttable presumption that if you are a frontline worker working in one of those industries and you contract COVID-19, that rebuttable presumption is that was contracted in your workplace, and you would be entitled to all of the rights and all of the benefits under the Occupational Diseases Act. So it's an important presumption, but it can be overcome with certain activities or things that your employer may have done during the course of your employment.
Okay, so under this existing provision, for what period of time are workers covered under these COVID-19 conditions?
Well, that's really one of the limitations of this coverage, and that is that here we are in October, late October of 2020, and this presumption is only covering people through the end of December of 2020. Now, I'm happy to report that there is some movement afoot in the state legislature to introduce into the in law an amendment to increase the length of time that this disease will be covered under this presumption.
Okay. And what benefits, if any, are available for workers suffering from COVID-19 illnesses?
So these benefits are threefold. The first benefit is payment of 100% of all reasonable and necessary medical expenses. I can tell you that I am handling a Occupational Disease Act COVID-19 case right now that resulted in a month-long hospitalization. The bills are over $375,000. Now, under our law, if we can prove that this is a work-related illness, all of those bills will be covered. All of the time lost from work will be covered at 2/3 of the average weekly wage. So you'll recall I told you earlier that we get to include overtime in the calculation of the average weekly wage for occupational disease claims. So that would be helpful to the employee. And finally, most importantly, is that you will be covered for permanent partial disability caused by this illness. This may result in death for those who are unfortunate, and the spouse of the decedent would be entitled to benefits amounting to 25 years of compensation for the loss of their loved one. It's money, it can't bring the person back, but it is a significant benefit that they are entitled to receive.
Of course. So have there been any other provisions in the Act providing a rebuttable presumption for certain illnesses in the Illinois Workers' Compensation Act or Occupational Disease Act?
Yes, rebuttable presumptions are not new, okay? They are around and have been around for a while. Firefighters have certain presumptions under both the Workers' Compensation Act and the Occupational Diseases Act. Now remember that Chicago firefighters are not covered under our statute. Also, coal miners have a number of different presumptions. There are also presumptions for exposure to certain levels of noise in the workplace. This is your hearing loss presumption.
So has your firm, Katz Friedman, successfully litigated cases utilizing this rebuttable presumption on behalf of any disabled firefighters?
Yes, absolutely. We've represented a number of firefighters throughout the state who have benefited from this presumption. And this presumption for them goes beyond, just one type of injury. It includes heart attacks, strokes, all kinds of things that firefighters who have really long-term cumulative stress are likely to suffer from. High blood pressure that we see related to smoke and things of that nature.
So does Katz Friedman presently have any cases pending on behalf of workers who are disabled from COVID-19?
We are representing a few dozen cases for people right now. Unfortunately, 2 of them are spouses of people who have died in the workplace, and a number of other individuals. I can tell you that I've successfully settled COVID-19 cases for 2 airline workers.
Got it. Okay. So moving forward, what recommendations do you have for workers who have been exposed to COVID-19 on the job to protect their benefits?
So the very first thing is to make sure you get all the proper treatment. Don't delay treatment. That's really critical. But it costs you nothing to call our office and make an inquiry about what your rights might be. We're always happy to provide a consultation at no cost, and we will outline for you what you need to do in each individual case. So feel free to call us.
Great, sounds good. Well, I think that's all I have for you today. Thank you so much, Richard, for that primer on COVID-19. Appreciate it.
Thank you, Andrea. Appreciate your time.